Hello students, welcome to EPG Parshala. I am Dr. Savita. Today we are going to discuss about the module Intellectual Property Rights and MSMEs under the paper Tourism and Hospitality Entrepreneurship and Legal Environment. After completing this module, you will be able to understand the concept of intellectual property rights, understand the types of intellectual property rights, and understands the need of the intellectual property right for the MSMEs. MSMEs are very important for the growth of the economy. It has a significant contribution in the exports, service sector, including tourism, employment generation, etc., and recorded higher growth than the other industrial and service providing industries. Therefore, MSME sector plays a vital role in developing the Indian economy. This sector is reducing regional imbalances and widespread income and wealth inequalities. Hence, government is making continuous efforts to exploit the potential of the MSMEs to the fullest, but because of the small size of these industries are facing problem in the marketing, production, technology, capital, skilled manpower, etc., which leads to the industrial sickness. Thus, the future of these MSMEs is in dark. It is a matter of concern that how these industries can be made competitive. The intellectual property rights can be one solution to make these industries competitive and can help in generating wealth. IPR and MSMEs. Intellectual property is growing out of one's ideas, thoughts, and intellectual creation of the mind. Today, government is making efforts to increasing its efforts considering its importance for the economy development. IPR means a number of legal monopolies over creation of the mind, both artistic and commercial, and their use. In simple words, IPR are the intellects emerged from the human mind, and the legal rights on these human intellects are called as intellectual property rights. These laws are applicable only in the country in which it is imposed. There is nothing like international patent. World Intellectual Property Organization was formed in 1967 as a part of United Nations, although it has been in use since long from 1888. India also has enacted various laws related to intellectual property from time to time. In past, only the tangible assets were given importance and there were laws relating to the protection of those assets. But now there are 7 forms of IPR, that is patents, trademarks, copyrights, geographical indications, industrial design, trade secrets, integrated circuits, and new plant variety. These are the oldest form of the intellectual property rights and are enforced to promote technological and economic development by recognizing the individual's creativity and intellect. According to the Act, patent is the allowance from the government to the investors and giving them the exclusive right to make and use their inventions, and it is for a limited period of time. According to the trade-related intellectual property rights, this exclusive right is for a period of 20 years, and after that, government has the right to publish it. Government publishes it so that new and better ideas can be generated and the better products can be made so that old one can be replaced. Intellectuals have the right to commercialize, transfer or to sell the license of their invention during this time period. The Indian Patent Act 1970 has classified the patentable inventions such as process. According to the law, process means new methods of production, research, testing, analysis, or the technological process that can be validated as new or unique. These are not the physical objects are in documented form. Machines. In the patent law, machines are physical object. It can be any product, instrument or any other physical item that is new or useful. Manufacture. According to the patent law, manufacture means any physical item has been made up by a new and unique way or material. Composition of matter. Composition of matter in a patent law refers to the mixture of the chemical compounds, medicines and botanical composition which is new, unique and are useful and do not exist in the nature of that particular state. Patent applications. Once the patent research is over, inventor fills an application for the registration which includes three parts. First part includes a written document which contains invention, its specification and claim. Second part contains the drawings which need to be clean and clear. Third part includes the declaration and oath by the inventor. Once the form is completed with all three parts, it is submitted to the patent officer, and if they find it complete, then notification is sent to the inventor. Patent examination. This step includes the throughout examination by the patent office and informing the inventor about the various problems of the patent grant. Once the examination is over, then after confirmation, patent is registered and the letter of the same is sent to the inventor. The patent process. Obtaining patent involve a certain steps as follow. Document disclosure. This is the first step of the process and comes when the inventor discloses his idea in the written. When the idea is disclosed, it needs to be filed for the patent. This is necessary to protect it and to give it legal recognition so that if someone steals the idea, there is a written record. Patent search. This step involves searching for the validity of the patent, whether such patent exists or not. The main objective is to find that whether the patent to be registered is original or not. Search can be done by the inventor himself or herself or by the attorney. Patent search includes searching for the resembling patent in the patent room of each office. This process ends when it is confirmed that no such patent exists. Utility patents. Patents approved for process, machines, manufacture, and composition of matter comes under this category and is granted for a period of 17 years. This is the most common patent type and excludes botanical creations related to plants and agricultural use. Design patents. These are the patents for any new or original ornamental design. When a manufacturer builds a new ornamental design for any of his product, then to avoid the duplicacy, he or she applies for design patent. For example, bicycle manufacturer who manufactures the new design for the bicycle or the shoe company apply for such patent. The life of the design patent is very short, as from 3.5 to 7 years. Plant patent. Plant patent is provided for the plants which are new and unique and do not exist in the nature. It is also granted for the period of 17 years. Types of patents. According to the patent law, patents can be classified as follows: utility patents, design patents, plant patents. Trademarks. There is Trademark Act 1999 in India, which administers the matters relating to the trademarks in the India. Trademarks are for the indefinite term. According to Section 2, subsection ZB of the Trademark Act 1999, trademark means a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others and may include shape of goods, their packing and combination of colors. A mark can include a device, brand, heading, label, ticket, name, signature, word letter, numeral, shape of goods, packing, or combination of color or any such combinations. For example, slogan of McDonald, I'm loving it. The symbol of Puma, etc. Trademarks help in identifying and purchasing a product or service because of its unique trademark and quality which meets the consumer needs. Who can file for a patent? According to the patent law, only the inventor can file for the patent, but there are certain other exceptions as per the law. If the inventor dies before applying for the patent for the invention, then her executor or legal administrator can file the patent. If the inventor has become insane or not is sound condition, then his or guardian can file for the patent. If there are two or more inventors, then they can jointly file the patent, and if any of the inventor disappears, then the joint inventor can file patent on his or her behalf too. Any person who files for the patent and is not an inventor or doesn't come under any category of rules is subject to criminal penalties under the law. Industrial designs. These can be any ornamental designs or the visual appearance of the product in two dimensions or three dimensions. These designs are the part of intellectual property and are regulated by the new Design Act 2000. This law is enacted to protect the designs of the industrial production. For the registration of the industrial design, designs should be new and original and should relate to the functional aspect of the article. This design registration is valid for the period of 10 years and can be renewed for the period of another 5 years. Types of trademarks. Service marks. There are the marks used to protect the service industry. All the trademarks of the service industry come under this mark. It includes hotels, restaurants, beauty and healthcare, software and hardware, assembly and maintenance, career and transport, etc. Collective marks. These marks are used by companies who produce the products collectively and can apply for the trademark in a group. Certification mark. These marks are for the standards. These marks confirm that the product has gone through the certain standard test and help in assuring the customer, for example, electrical goods. Well-known marks. These are the marks which are extremely popular and are protected more. Therefore, people cannot imitate these popular marks. Registration of trademarks. Registration of the trademark is done through a valid process. Firstly, the applicant has to apply for the trademark in the written by doing all the information like address, identification proof, citizen proof, etc. If the authorities are satisfied, then he or she has to provide the drawings in the written and clear format and then to provide at least 5 specimens of the drawing. If the application found incomplete after all the examination, then trademark will be issued. Copyrights. Like patents, copyrights also protect the individual, but it is for the intellectual work and is related to the musical, dramatical, literary works, cinematography, and sound recording. It protects the individual's original work and gives him or her the right to authorize others to do certain acts on it. A copyright protects the work for the age of the originator plus period of 50 years. For the cinematographic work, it is protected for the period of 50 years after it is made public, and for the photographic work is for the period of 25 years after the work has been done. There is an Indian Copyright Act 1957 for granting the copyright. Copyright is not granted for every work. There are certain principles as following. It is not granted for an idea and is always granted for the ideas expressed in the material form. It should not be the violation of the already existing copyright in a different manner. There is no copyright for the live events. Creators generally sell the copyrights of their work to individuals or the companies who offer them the best payment and can utilize their work effectively. These payments are always on the basis of the amount of work used and thus help creators in making money out of their unique work. Objectives. According to the law, there are two main objectives. Encouragement to the original work. The main objective of granting copyright is to encourage the writers, composers, artists, and designers, etc., to create original work, and for that their work is being protected for a certain period of time. Thus, encouragement is given to exploit the work for monetary benefits and issuing the license to the film producers, publishers in return of money to use their work. Protection to the originators. Another objective of the copyright is to protect the original work of the originator so as to avoid its reproduction and prevent the originator from the exploitation. Therefore, copyright help in avoiding piracy and protecting the original work. Geographical indication. These refers to the words, qualities or symbols that describe about the origin of the product and the reputation is attached because of the origin. It is essential that the qualities, reputations, etc. must be because of the place of the origin. It can be any geographical place name, a symbol, outline of geographical idea, or anything else capable of identifying the source of the product. For example, Darjeeling tea, Banaras silk sarees, Kullu shawls, etc. It is special right given to a particular community. Therefore, the benefits of the registration of geographical indication is mutually shared by the all members of the community. These indications are protected under the Act so that the uniqueness of the product can be maintained. In India, there is Geographical Indication of Goods, Registration and Protection Act 1991, which was enacted in India being the member of the World Trade Organization. Industrial designs. These can be any ornamental designs or the visual appearance of the product in 2 dimensions or 3 dimensions. These designs are the part of intellectual property and are regulated by the new Design Act 2000. This law is enacted to protect the designs of the industrial production. For the registration of the industrial design, designs should be new and original and should relate to the functional aspect of the article. This design registration is valid for the period of 10 years and can be renewed for the period of another 5 years. Trade secrets. There are the confidential business information which must be secret, that is not accessible to the people, and information should have some commercial value. The owner should have valid reason to keep it secret. According to the Uniform Trade Secret Act 1970, trade secrets can be defined as information including a formula, pattern, compilation, program device, method, unique technique, or process that derives independent economic value, actual or potential, from no being generally known to and not being readily ascertainable by proper means by other persons who can obtain economic value from its disclosure or use, and is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. Any type of data or information can be trade secret but should involve the commercial person and valid reason to keep it confidential. Integrated circuits. Semiconductor Integrated Circuits Layout Design Act 2000 is enacted to protect the intellectual property related to the semiconductor integrated circuits. It means product having circuits containing transistors, resistors, and other elements of the circuit design. It protects such integrated circuits which are new and unique. Protection of new plant variety. The Plant Variety Protection and Farmers' Rights Act 2001 was enacted in India to protect the new plant variety. At the early stages, only 12 species of the crops are considered for registration, including rice, wheat, maize, sorghum, pearl millet, chickpeas, green gram, black gram, lentil, kidney beans, etc. This law was enacted with the objective to protect the farmers and to conserve India's agro biodiversity. Need of IPR for MSME. Micro, small, and medium enterprises are actually helping in the economic development of the country by providing employment, income generation, exports, etc. These industries are important for the country, but due to lack of financial resources, skilled manpower, etc., and these industries becomes sick. Therefore, for the survival, such industries should become competitive and should strive for the competitive advantages through innovations. innovations play an important role in providing the enterprises, and the innovation IPR is must. There are several reasons that why India needs IPR. First one is Indian competitiveness is based more on the cheap labor and raw material, but it can be a knowledge based economy. For that, there is a need of IPR to convince and protect the originators about their work. This will boost the motivation to bring acknowledge to the country. Moreover, India is a WTO nation, and all 149 WTO nations have agreed for the IPR protection by including trade related intellectual property rights, that is TRIPS. IPR has proved to be helpful and useful in various economies and therefore can also be helpful for the MSMEs as follows. It can prevent the competitors from imitating others' products and services, can help in making a corporate image through trademark, can help in preventing the resources invested uselessly in research and development. IPR helps in increasing the market value of the company. Uniqueness and innovations can help in reaping more profits. Patents, trademarks, copyrights can help in protecting the entrepreneurs and gaining competitive advantage. Helps in generating money by issuing license, commercialization and sale of intellectual property. But to gain advantage from the IPR, they should be properly managed and entrepreneurs should be made aware of the importance of IPR. So, there is a need of IPR for MSMEs but can only be of importance if entrepreneurs know about it. So students, let's now summarize what we have learned in this module. Micro, small and medium scale industries are the support for the Indian manufacturing sector. There are about 26 million MSMEs which employ more than 60 million people and shares about 45% in manufacturing sector and hold about 40% of exports and contribute to the 8% of the 8% GDP of the country. But they face several challenges like technological problems, lack of finance, IPR related issues, unawareness, etc. Therefore, unable to register for the patents, copyrights, trademarks and intellectual property, because of which they are losing their competitive advantage. Therefore, to gain the competitive strength, they should be aware of the intellectual property rights and the government should take steps to promote the importance of IPR for the entrepreneurs because IPR can help them in gaining competitive advantage by being unique and innovative, and moreover by commercializing these IPs they can generate good profits from the business. Therefore, IP has the potential to raise the business value of the entrepreneurs and help in making them more competitive and financially strong.